Okay, Jen. When the judge gets back in, she's going to put you under oath, answer loud, yes ma'am, no ma'am. She's going to say it's a court decision and yours alone, not theirs. Make it your decision, yours alone, not to request any lesser. It's your pros and cons and all that. Should be. No, I saw her out there. She said, hi.
You want us to?
I will be more than happy to do it if you want. Yeah, absolutely. Is she judge on her way in? Yeah.
Oh, well, Jessica. Well, John.
You ready?
Well, first we're going to argue the jury instructions and then...
Hey, just so you know that when we finish the jury instructions, we're going to take a break because I got to go back and get them. I don't have like access to print them.
Oh, okay.
It'll be,
Thank you.
Okay.
I'll get someone, I get to email someone.
Yeah.
Let me call Stacy and tell her 4674.
46747. That'll be Karen.
Hey, Karen. Hey, Barb. 46. Okay, you're
Ask her if she can transfer you to Courtney.
to Courtney. This is Crystal Bruce. I'm talking to you. Sorry.
Circuit Court is back in session.
But she's trying to get our jury instructions.
I'm just trying to set it up so I can have one.
Well, we can't make our
final agreement until all the evidence is done.
No, I agree. I just
Okay.
have someone to bring it to me when we do that.
Oh, I see, okay. All
Didn't
right.
get anyone?
Okay.
I don't want to close this.
Okay, so I gave you that extra 15 minutes, Mr. Trevina, and where are we now?
I'm sorry, Your Honor, I was just at my client's request conferring with Ms. Mee's mother regarding those issues, and she had asked me to do that, and I just finished my discussion.
Okay. Okay, so where are we now?
The defense, I believe, will be resting when the jury returns, and Ms. Mee will not be a witness in her own case. Therefore, we will be requesting the instruction with both paragraphs. Ms. Mee will not be requesting any lesser offenses whatsoever. I know the state has authority on the one to object, but we're asking for no lessers.
Okay. All right. So it's time for me to have my colloquy with Ms. Mead then about whether or not she wishes to testify. Is that correct, Mr. Trevina?
Yes, Your Honor.
All right. You want to stand up, please, ma'am?
Yes, ma'am.
Do you swear or affirm to tell the truth?
Yes, ma'am.
Thank you. You put down your hand and stay standing. What's your full name, please?
Jennifer Ann Mead,
And how old are you, ma'am?
22.
How far did you go in school?
About 10th grade.
You can read and write, ma'am?
For the most part, yes, ma'am.
Okay. Have you had sufficient time to discuss with your lawyer, Mr. Trevina, the issue about whether or not you wish to testify?
Yes, ma'am.
Have you also had sufficient time to discuss with your lawyer any request for lesser included offenses?
Yes, ma'am.
Did you need any more time to talk to Mr. Trevina about either of these issues?
No, ma'am.
All right. You understand that the burden of proof is on the state to prove the charges against you,
Yes, ma'am.
that you are not required to disprove anything.
Yes, ma'am.
All right, what medication are you taking today?
Today I have taken Ativan, Accessory, and Claritin.
Okay. And do those medications assist you in your daily life?
Yes, ma'am.
And how long have you been taking those medications?
My Ativan and my Claritin I've been taking for almost 3 years, and the Accessory for probably about a little over 3 months.
Okay. So those medications do not interfere with your ability to understand what's happening here. Is that correct, ma'am?
No, ma'am.
All right.
I'm sorry, Your Honor. I had heard her mention when you did this colloquy at the beginning of the trial that she also was taking Thorazine. I don't know if she's still taking that or if it stopped. Why?
I still am taking that. I only take it at nighttime, though.
Okay, so you weren't taking that this morning?
No.
Okay, so you take that like before bedtime
Yeah,
at night?
before bedtime.
All right, very good. And so to be clear, none of the medications that you take, you feel interfere in any way with your ability to understand what's happening here. Is that correct?
Correct.
Okay. You understand that if you did testify, you'd be subject to cross-examination by the state,
Yes, ma'am.
who would do their best to try to discredit you.
Yes, ma'am.
Has anyone promised you anything in order to get you to make this decision?
No, ma'am.
Has anyone threatened you in any way in order to get you to make this decision?
No, ma'am.
So you understand that there's two decisions that are yours and yours alone. One of those is whether you have a trial or enter a plea, and the other one is whether you testify or not. Do you understand?
Yes, ma'am.
So it's all good and well, and you should talk to Mr. Trevina, you should listen to his opinions. It's fine that he or you have talked to your mother, but you understand that the decision, just like whether or not you went to trial, the decision about whether or not you testify is up to you and you alone. Do you understand?
Yes, ma'am.
All right. So you've had the benefit and the advice of your lawyer, correct?
Yes.
But you've made this decision of your own free will, is that correct?
Correct.
And do I understand correctly that you've chosen not to testify in this trial?
Yes, ma'am.
All right. Let the record reflect the defendant has decided that she does not wish to testify and that that decision is freely and voluntarily made. Then the second issue I wanted to discuss with you was whether or not you wanted any lesser included offenses. Just stay standing there. Let me ask the state something. Is the state going to ask for any lesser included offenses?
We are, Judge.
Okay, what?
Manslaughter.
All right. So, the lesser included of manslaughter is still going to be given because the state is requesting it.
Okay.
But what had been your position on lesser included offenses, ma'am?
I don't understand what you mean.
Were you wanting to just have guilty and not guilty?
Yes, ma'am.
Okay. And you understood then with that system, if the jury found you guilty of anything under what you were requesting, I would have to give you life in prison without parole.
Yes, ma'am.
And there would be no choice.
Yes, ma'am.
Okay. Under the law, there's one lesser, which is manslaughter, that if either side requests it, I'm supposed to give, so I will be giving it. Were there any other issues, Mr. Trevina, regarding lesser included offenses that you discussed with your client that I should be discussing with your client? Did you talk about any other lessers besides manslaughter,
I did not-
essentially?
No. I didn't anticipate the state that they
Okay.
would be requesting. Can I have another minute with her?
Yes, of course.
I see. She also has her accessory. Your Honor, in view of the state indicating that they are requesting over our objection the manslaughter instruction, which they're entitled,
Right, absolutely entitled because it's a Category 1.
we will be requesting a discretionary instruction on accessory after the fact.
Okay. And what number is that?
That is, it's in here. I just did this in another. Judge. I'm
Sure.
trying to locate the number for it.
Okay, now I don't see that as a Category 2.
It's not listed as a Category 2, but I can inform the court, I have requested it in homicide cases. It has been given in homicide cases at my request, as recently as Judge Peters a few months ago in a murder trial that we were doing. Oh, here it is. 3.5C in my book.
Okay, so let's theoretically decide if we can make it fit. To prove the crime of accessory after fact, the state must prove the following, we'll have to see if it's 4 or 5. Doubt. So a first-degree murder was committed by, I assume you want LaRon Rayford and Lamont Newton?
And/or Lamont Newton.
Okay, so just,
Should do it as we go along, Judge?
yes, please.
All right, give me 1 second. You want murder in the first degree, Mr. Trevino, or do you want murder, felony murder?
Felony murder. Well, no, because they're talking about...
Murder in the first degree is what's
Yeah.
charged.
Yes.
Okay. Okay.
Okay, so you got the Lamont Newton and/or LaRon Rayford, or you can put it in the other order.
I'm ready, Judge.
Okay, after the first-degree murder was committed, Jennifer Me,
We would request assisted, aided, or attempted to aid, and again, LaRon Rayford and/or Lamont Newton. I don't think maintained makes sense in the facts in this case. I'm not even sure what that means, honestly, in this context.
so you're typing, right?
I am, Judge.
I thought I was watching you type, so I was just waiting until you looked done. I'm not rushing you.
Judge, I'm ready for the next
Okay,
one.
and at that time, Jennifer Me knew that LaRon Rayford and/or Lamont Newton had committed the first-degree murder. And Jennifer Me did so with the intent that LaRon Rayford and/or Lamont Newton avoid or escape detection, arrest, trial, or punishment. Now, what kind of felony is this? I think, is the level of it based on,
It's
what-
based on the primary charge.
so does that mean it's a 30-year felony?
believe, it may be a PBL. It's one step down.
77703.
Don, you agree L number 5 does not apply?
Yes. You agree, Mr. Trevina?
Yes.
Okay. If the felony offense committed is a capital felony, the offense of accessory after the fact is a felony of the first degree. So it doesn't say life. It says first degree, so it's a 30-year felony.
Okay.
So if we do that as we usually would, that would go before manslaughter, because it's a higher offense in lessers, and it would go on the verdict form before manslaughter, which sort of runs contrary to our logic, but when you look at the level of the felony, so you all want to ask for that 30-year felony. That's fine, if that's what you want to ask for. I'm just wanting to be clear.
Yes,
Just me
ma'am.
have a seat. I'll get back to having you stand up. I just want to make sure you and your lawyers are in agreement and on the same page. So let me be clear. I am happy to give the accessory after the fact. It seems to me under the law that it goes after first-degree murder and before manslaughter, both in the lessers and on the verdict form. So the maximum penalty as charged is, and the only penalty, is life in prison if found guilty. The maximum penalty on accessory after the fact would be 30 years in prison. The maximum penalty on manslaughter would be 15 years in prison. Does everybody agree with me on the possible penalties? Lawyers?
Yes, Judge.
Yes, Your Honor.
Okay.
Also, Judge,
Uh-huh.
again, now that we're looking at this in a new light, based on the state's request, I believe also the second-degree felony murder should also be given.
Based on what?
The evidence that was presented.
Well, but what's the felony? Like, you don't just get it because there's a second degree. Second-degree felony murder is based on the felony, right? Just like first-degree felony murder. That's why, you know, when I first looked at first-degree felony murder on its own, because most of the time that it's charged alternatively with premeditated, and you do the lessers like that. But on the occasion like here, where it's only first-degree felony murder, it was the first trial of the co-defendants that I'd had just that, and I looked at it and realized manslaughter was the one that they said was the category 1. They did not say second-degree felony murder was an automatic lesser. Now, I will certainly consider it. I'm just saying you have to tell me what felony it is. So let me see. That is what, 7, what's the number? Where am I?
7.5, I believe.
Okay, first-degree felony murder, 782-041A.
Attempting
782,
consequence, attempting or escaping. Was not the person actually killed. Was the person that, if applicable, was killed by.
trafficking, arson, sexual battery. No, wait. Wait a minute.
Right? Is that what we're getting at?
I think so.
Sorry. Or manslaughter. Could be manslaughter. Yeah.
So just tell me what it is you're asking for.
7.5 5, felony murder, second degree. If we want to step through the elements,
What's the underlying felony?
manslaughter.
That doesn't make sense. She's
The
punished.
lesser
Can't
of- All right, then, a lesser of robbery.
Unless there was another person that was killed and the manslaughter for that person
But it's
is the
confusing
underlying
because
felony.
They have manslaughter as a mandatory category 1 to felony murder. I guess you could ask, why is that considered a mandatory 1?
Because the Supreme Court says so, is exactly why.
Good answer.
Thank you.
I suppose we could, what's the standard lesser on robbery? Is it theft? Let me look real quick. My thought process would be, it would be the step down on the underlying offense, whatever that would be.
Well, I think you gotta mainly stick with the chart on first-degree felony murder.
I have that chart in front of me, and it's showing in my book, if it hasn't changed, the category 1, as we already discussed, is manslaughter, and then category 2 is second-degree depraved mind murder, which wouldn't apply, second-degree felony murder.
Right, and so then all I'm saying is, tell me which felony you're saying it applies to.
All right, let's find robbery for a moment. Do you know the number for robbery? Go to the front end. It's the, 15.1. There we go. Category 1 on a robbery. Were we reading robbery as just a robbery with?
It's like in the instruction.
I'm just trying to recall without looking at it. Was it just robbery without a weapon? Let me see what the state had proposed.
Yep.
Okay, so robbery without a weapon. Category 2 on robbery can be attempted robbery or grand theft. And a number of others, but I'm thinking the applicable requested one, Judge, would be attempted robbery,
No, because
because that's
one
incorporated.
committed by a person engaged in the perpetration of or in the attempt to perpetrate any is the felony murder, first-degree felony murder. Like we believe we discussed that yesterday. Now, here's something that's confusing me a little bit. If you look at 78204, the murder statute, 3.
Oh, 43, Your Honor?
Yep.
I have it.
By a person, so I guess second-degree felony murder is by a person other than the person engaged in the perpetration of or the attempt to perpetrate such felony. The person perpetrating or attempting to perpetrate commits murder in the second degree. You guys read that, Mr.
Yes,
LaBruzzo?
I'm reading, I'm trying to do some research on it.
Yeah, I'm trying to figure out what they mean.
I mean, this is what it's reading now. These are the predicate offenses. First degree.
Okay, so do the verdict form, well, we'll do accessory after the fact as included as B, and then manslaughter as included as C for
Rid
now.
of this robbery again.
And then we may change it some more. Okay, Mr. Trevino, those poor jurors have been sitting there 40 minutes already, so.
Sorry, Judge.
Judge, I think what, and I'm not trying to think what they're thinking, I think what they want to say is that there's another felony that was being committed, correct?
A lesser felony.
A lesser
that-
felony, probably something on a third-degree felony murder. I think the confusion, Judge, is that the murder in the second degree is based on whether or not the person intended the death. And I think that's why I don't think it's applicable. I think that's what that, I'm doing the research and I'm not really sure I'm getting it correct. People are sending me some emails.
Fred Schaub seems to know this inside out because we debated it endlessly when we had our last homicide trial. But as I recall,
If I may, if I don't mean to cut you off, Mr.
No, no, go ahead.
But a second-degree felony murder is a situation where two individuals go in to rob a bank or rob a convenience store, and the clerk kills one of the bad guys. You can hold bad guy number one responsible for bad guy death number two, even though that was not even remotely contemplated within the
Thank you.
situation of the murder.
So that's why we never use it, because that hardly ever happens.
Right.
Right.
Okay.
I think what they're trying to say is they want,
So that's not one of the original defendants. It's not one of the original people who set the plan. It's if a
Right.
third party is killed in the course of them committing that by, a fourth party is killed by a third party.
Right.
Essentially.
Person other than the.
Right,
first, yes.
right. Okay, thank you.
okay.
Do you have any reason to doubt that being the law, Mr. Trevino?
no, I.
All right, so are you asking for anything else?
I noticed that there is an attempted felony murder, which just, the name of it sounds odd, that there would be an attempt of felony murder.
Okay. Going back to our good friends in the Supreme Court, first-degree felony murder, Category 1, manslaughter. Category 2 is, which Category 1 I give no matter who asks it. Category 2, there has to be evidence to support it, but I will be happy to give anything for which there is the slightest evidence to support it. Second-degree depraved mind murder, second-degree felony murder, which we just decided didn't apply, and we all agreed. Third-degree felony murder, ag battery, ag assault, battery assault. That's what listed. So I gave you something that wasn't on the list as the accessory. If, with this, I mean, I feel bad for these poor jurors. They're just sitting there and we're just throwing out stuff. I said Tuesday we needed to be ready on what we wanted for lesser, so I'm happy to consider any. Let's just do our considering. Yes, Mr.
Still
Labruzzo?
haven't put to bed their request for an independent act as well.
Oh, we're not to that yet. We're still at this. I haven't forgotten. I have my little case law right here.
Third-degree felony murder would be applicable because
And what would your felony be?
the wording is identical to the first-degree felony murder and all of these felony murder instructions, it appears.
No, in that one, it's, if it's any other felony other than the listed ones. So, first-degree felony murder is what's alleged here. Second-degree felony murder is when it's a person that's not originally involved in the crime as victim or defendant. And third-degree felony murder is for any felony other than the enumerated felonies.
So this one, we could then argue the,
What would be the other felony?
well, I'm looking back again at robberies, lessers, to try to get an idea. They have robbery by sudden snatching as a lesser, Category 2. They have robbery by sudden snatching with a firearm as also a Category 2. Would that work, Your Honor?
Does the state have anything they want to say?
Judge, I don't think that's the appropriate non-enumerated felony for felony murder third degree.
And by that, what do you mean?
Judge,
I'm not saying you're wrong or right, I'm just saying,
because it's listed as a potential Category 2 lesser doesn't necessarily mean that it can be the predicate offense.
right. Well, third-degree felony murder is supposed to be any other felony. Now, whether that means a lower degree of robbery, I've never had that argued before. So, go tell the jurors they can have a 20-minute break and that I apologize. Thank you. So let them go down and get coffee, smoke a cigarette, something. All right, so Mr. Trevina, if you want something, you're supposed to ask for it specifically.
So third-degree felony murder, underlying offense, robbery by sudden snatching with a firearm.
You're asking for it with the firearm? She has no place in the original charge. Is she being charged with the firearm? So did you want to add that in a lesser?
I mean, it is a lesser, and the robbery.
But she's not,
Go
okay.
ahead.
The felony murder is the robbery. Obviously, okay, if you want to add the gun back in when I'm not using the gun specifically against her earlier, that might not make a lot of sense to the jury, because there's no finding a firearm like there would be with the co-defendant allegations. There's no firearm enhancement. So if you're telling me that's really how you want me to do it, I will consider it, but I don't know that that makes a lot of sense for your client.
Just have a moment, Your Honor.
Uh-huh.
Co-counsel. We're looking at theft as an underlying consideration. Given the amount of goods that allegedly were taken from the victim, I'm thinking it would be a first-degree petty theft. Do you agree that it was under $300?
I would agree it's not a felony. It's not a felony theft.
Right. It's one of the listed as a lesser Category 2 of robbery.
So what are you asking it for? Like you want a petty theft as a lesser of this charge? Is that what you're saying?
For third degree, right.
But that's not a felony.
You're saying it has to be an underlying felony to,
Yes, that's what third-degree felony murder
let's
says.
see.
Any felony other than.
They're not leaving you many options here. It wouldn't be proper to call it a grand theft. I don't think we can request it under those circumstances.
You couldn't request it under grant. Well, you could, but there's no evidence to support it, unless it
Right.
was a very expensive wallet and they forgot to tell us.
I have no other substitute felonies that would
Okay.
be
I
supported by the
just wanted to be
facts.
clear. I was happy to look at that for you.
And we
So,
appreciate that, Judge.
all right, so right now, for Mr. Labruzzo typing away on his little computer, what you're looking for is the first-degree murder as charged, the defendant is guilty of accessory after the fact as included, and the defendant is guilty of manslaughter as included. Is that correct, Mr. Trevino?
Yes, Your Honor.
All right, so those are the lessers that you're asking for.
Yes, Your Honor.
Okay. Ms. Mead, did you want to discuss that any further with your lawyer before I finish questioning you? Are you comfortable? I'm not trying to make you comfortable. I'm just trying to say, do you want to talk to him any further about it, ma'am?
No, I'm comfortable.
Okay, then if you could stand back up again, ma'am. So we haven't taken a break. We've just been sitting here during this conversation. So I assume you're still not under the influence of any other alcohol or drugs that would affect your ability to make decisions here. Is that correct?
That's correct.
All right, and you've heard your lawyers talk about what lesser included offenses they're asking for.
Yes, ma'am.
And you were going to ask for none, but since the state asked for manslaughter and the law says I must give it if either side asks, then your lawyer asked for accessory after the fact. Do you understand that?
Yes, ma'am.
So as it is, if you were found guilty of first-degree murder, I would have to give you life in prison. If you were found guilty of accessory after the fact, I could give you up to 30 years. If you were found guilty of manslaughter, I could give you up to 15 years. Do you understand that?
Yes, ma'am.
Are you in agreement with your lawyers about the lesser included offenses?
Yes, ma'am.
All right, and nobody threatened or forced or made you do that, is that correct?
That's correct.
Thank you very much, Ms. Mee. You may be seated. Okay. Now, does the defense have any case law for me? You had requested that independent act instruction. What number was that again, Mr. Labruzzo?
Judge, it's located at
3 something, isn't it?
hold on a second, Judge,
It's at 3.6L.
Thank you.
Judge, I can't remember if I put I had some new case law I provided to the court. I don't know if I put it up there, I gave a copy.
No, I copied Cannon, oh wait, maybe you did. Yes, you did. I had Cannon copied for me, so I read that over lunch, which you had cited this morning.
Yes, Judge.
And then here is Lovett, you just gave me from the
Yes,
Supreme
Judge.
Court, and Jones. So Lovett is Florida Supreme Court 94, Jones is 3rd District 2002, Rodriguez, 2nd DCA 91, and then I have Cannon, 1st DCA 2009, Thomas, 2nd DCA 2001, and Perez, 3rd District 98. Okay. Did the defense get any law to support the giving of the instruction? This looks like this is you, Mr. Camarino.
Your Honor, thank you, Judge. Earlier, I gave a copy of Dell versus State, but within Dell, Judge, was the Rodriguez versus State, so I was going to actually rely on Rodriguez, and
Okay.
Your Honor has a copy of that.
All right, I will look at it. Just a second.
Judge,
Let me finish, please. Then I'll be happy to hear from you. Okay, did you want to say something? About
I'll let
this
him
case?
make his argument. I
Okay,
have no question.
all right. Okay, go ahead, Mr. Camarino.
Judge, thank you. The case that the State cited, before I rely on the Rodriguez case, the Thomas versus State, 2nd DCA, 787 Southern 2nd 27.
Came out of this building. I'm familiar with it.
Oh, okay. Did not know that, Judge. With that being said, Judge, the proposition that, quote, where there is any evidence introduced at trial which supports the theory of the defense, the defendant's entitled to have the jury instruct on the law applicable to his theory of defense when he so requests. Judge, one of the reasons why we called Ms. Sharon to the witness stand, Judge, was that the proposition that when Ms. Mee left the residence, again, if you take it for its face value as to what she had to say, if you believe the state's proposition, the state's theory that she was out there engaging or facilitating, preparing for this encounter between the two other co-defendants, Judge, Ms. Sharon indicated when she testified that it was then that they received a phone call, or a call was made, and they went into the closet and removed the bag. Ms. Mee was not present when this bag was removed, and so assuming, I think that's all we can do is assume that the gun was in the bag, because I think that's what Ms. Sharon had said. Judge, I would submit that was done without my client's knowledge. It was outside the scope of what she had intended. I think at best, again, in light most favorable to the state, she was aware of perhaps this unarmed robbery. Judge, no indication at all that she knew or was aware or anticipated that that gun would be retrieved from the bag that was within the closet. If you look at the Rodriguez case that I alluded to, that's in the Dell opinion, in Rodriguez, the court reversed the conviction and held that the independent act or instruction should have been given. There, the theory of the defense was that the murder was a spiteful act of the co-felon as an afterthought to the attempted robbery rather than an attempt to eliminate any eyewitness. So, Judge, again, in Rodriguez, the second DCA case at 1990, the court felt that independent instruction should have been given. Some of the other cases that's cited by the state, it's clear that robberies were anticipated, the co-felons were aware that guns were being used. In the Rodriguez case, the co-felon or the appellant was outside waiting, and apparently when the cashier refused to give the money, the co-defendant was about to leave and then came back and out of spite shot and murdered the cashier. And so again, the independent instruction was warranted there. So we would submit that in this case, if at best you're to believe that she facilitated this encounter, Judge, there's no evidence at all whatsoever to support that she was aware of the gun. In fact, again, the evidence supports that it was more of a thought that came across perhaps at the last minute by the two co-defendants when they just went in, retrieved this bag, and walked out. So I would submit there's no evidence that she even knew of the gun, and so I would submit that under the authority of the Rodriguez case that the independent act instruction should be given because it does fit into our theory of defense.
Okay. Mr. LaBruzzo?
Yes, Judge. Addressing primarily the Rodriguez case, Judge, there's one factual distinction between this case and all the other cases that the state provided you. In this case, as described by counsel, one man is the getaway driver, if you will. Another man goes into the store to effectuate a robbery, does not complete a robbery. The clerk does not give him the money. And then in upset, he walks out of the store and then as an afterthought turns and shoots him. In fact, there was no robbery. There was no exchange of property. And therefore, the court decided not to give it because there had not been a completed robbery, which is completely in opposition to what we have here. There was, in fact, a robbery of Mr. Griffin's property, and the state has presented a case as to that. As to the knowledge of Ms. Mee, she does indicate to the detectives that she has knowledge of a firearm, and a firearm involved in a robbery is a foreseeable consequence. I think the case that's most informative on this issue I provided to the court again after the break is the Lovett case. It's the Supreme Court case. It pretty much says, it asks the question, is there a causal connection between the robbery and the murder? And I think in this case, as it was in the Lovett case, that there is, because it allowed the perpetrators to evade immediate detection, and it also allowed them to evade immediate apprehension. Ms. Mee clearly benefited from that and was able to leave the area successfully and only to be caught 26 hours later. But again, she had benefited from this. There is a connection between the robbery and the murder, and therefore the court should not allow independent instruction based on the Rodriguez case. The Dell case, for which they provided to you, I also provided you the Jones case, just so the court's aware. The third DCA, some 6 years later, revisited the same issue and kind of calls into question some of the holdings in Dell, but I presented it to the court. I think that the court, based on the second DCA opinions and the Supreme Court opinions I provided to the court, that the instruction should not be allowed, and it's well within the discretion of the court.
Okay.
Judge, if I could, when you're ready, Judge, just one last comment to make.
Please.
Go ahead
ahead.
now, Judge.
Yeah, go
Okay,
ahead.
Judge, in terms of Lovett does stand for the proposition that the killing lessened the immediate detection and it facilitated the subsequent apprehension. I'm just trying to emphasize that in this case, there's no evidence that Miss Mee, just because she had seen the gun before, she identified the gun, that's fine, but there was no evidence to support that that night she was aware of a robbery by firearm. So I'd submit that it was not a foreseeable consequence that somebody could die as a result of a robbery when she was not made aware that the gun was going to be involved in the robbery. So I would submit that at best.
But there's no evidence that she wasn't made aware of it. It's like, do you understand what I'm saying?
I understand.
So where we are in this is there's no evidence of, that they went beyond the plan. The language of the plan, I mean, she, clearly in the statement to her mother, she did not want, it went wrong to her that somebody ended up dead. So the perception was, I think, may very well be true that nobody expected that the victim would fight so hard. But anyway, so did she say, I knew there would be a gun in the blue bag? No. Did she set up the whole thing? Did she know there was a gun in their house? Did she know that, was there evidence of this? That they were going to commit a robbery that she had set up? I'm just talking about what evidence there is in the record.
Right.
And part of the reason I couldn't rule on this is I didn't know what evidence there was going to be by the end of the trial that there had been a plan and then there wasn't a plan, or that something went outside the plan. So, these cases are pretty consistent that there has to be some evidence that it's specifically outside the plan, or that the defendant abandoned the plan. That Cannon case, and the first DCA over the years has had a lot of well-written opinions, is at 18 Southern 3rd 562, is one of the more recent cases. And it describes the independent act doctrine is applicable when one co-felon who previously participated in a common plan does not participate in acts committed by his co-felon which fall outside of and are foreign to the common design of the original collaboration. Where, however, the defendant was a willing participant in the underlying felony and the murder results from the forces which they set in motion, no independent act instruction is appropriate. And it says the trial court did not abuse its discretion in denying appellant's request for an independent act instruction because there was no evidence in the record to support this theory. There was no evidence to show that the defendant abandoned the original plan, in this case they just named the parties, and he never testified that he knew at the time of the shooting that the man he shot was not so-and-so. So if there's any evidence to support the defense, I think you're entitled to it. And then I was looking at, what was the name of the one out of this building? Was that Thomas? And in that case, there were consistent statements from the defense that he had tried to halt the robbery when they learned that there was a gun. And I can certainly understand and agree with the second DCA's ruling there, and we all just do the best we can in court. It's, so 787 Southern 2nd 27. So the independent act instruction is an instruction that requires some evidence to support it, and the mere saying that that's our defense isn't enough if there's not actual evidence to support it. So I'm doing the best job I can. You've made your record. I'm going to deny the independent act based on the fact that there was no evidence in the record that, assuming the jury believes she participated in the plan, but I've got to look at the evidence that there was no evidence in the record that if she was involved in the plan, that she later separated herself from the plan, or that She didn't, there's no statement, I didn't expect there to be a gun, that wasn't the deal, there was no statement like that. Okay, so I've ruled. All right, so, Mr. Labruzzo, that can come out of the packet. Is there anything else we need to discuss regarding instructions?
Just briefly, Judge, it's grammatical. The introduction to homicide states, second paragraph, murder in the first degree includes the lesser crime of manslaughter, both of which are unlawful.
Yeah?
Accessory after the fact is a completely separate crime, and again, the state wasn't asked, but we would object to that instruction. We don't think it fits the facts of this case. The court's ruled, so I understand that.
Right, I understand. So, and Mr. Trevini, you're telling me as an officer of the court that Judge Peters gave that instruction?
Absolutely. Mr. Waluda was present with me.
Okay, very good.
I just need to make sure that I'm not to put accessory after the fact, because again, I don't think it fits there, but
Okay.
we are talking about lesser.
Okay, on the introduction to homicide, which is Mr. Labruzzo's question, you guys understand? Do you understand? Okay, a judge is supposed to read that instruction exactly as it is. So what Mr. Labruzzo is saying is that he doesn't think accessory after the fact goes in introduction to homicide. I tend to think he's correct about that. That doesn't mean you don't get it as the lesser, but introduction to homicide, for years, we had to read it word for word, and we couldn't even take out the lessers that didn't apply. For years, we had to do that. So now that's not the law, but I'm strict about reading it like the Supreme Court says. So you don't have a problem with that?
Of course.
Okay, well, thank you. All right, so then your next question, Mr. Labruzzo, and I know you're objecting to me giving the accessory after the fact. I got
That's
it.
it, Judge.
Thank you. Okay.
No, that's it.
So then, you've done the lesser page, I guess. So accessory after the fact is going to go before manslaughter there, right?
Yes, Judge, it does.
Okay, and then, so I guess when somebody comes up with a packet of instructions, I could read through them during the first closing?
Yes,
How
Judge.
long did the state want for closings altogether?
An hour and 15, Judge.
All right, what do you want, hour and 15?
I was going to ask for an hour and 30 minutes.
All right. Okay, so you both can have an hour and 30 if that's what you want. All right. So if you would have them do a copy of the instructions and just give them to the deputy at the door, the deputy can give it to me, and I will read it. Everybody can get one. Maybe you could have three, one for the, if somebody else wants to read it at the state's table. Obviously, with closings being that long, I'm going to give the jury a break during it. Okay. You want to come look at the verdict forms, please, lawyers? So when they come back in, well, you could rest now if you want. I will, thanks. Tell them if they need a comfort break to take it. Not leave the room, just go to the bathroom, so we don't get them in there and they have to use the restroom. We'll give you one, don't worry. Okay, are the verdict forms okay? Yes. Yes, she didn't throw away any of them.
How many
So
copies?
murder in the first degree, second accessory after the fact is included, third manslaughter is included, not guilty. I'll leave the verdict form up here if anybody wants to waive it.
And how many copies should I bring, Judge?
3.
Huh?
I want to look at one, and I assumed one at each table. If you want more than that, that's fine.
Okay.
Then we'll read through them, and on hopefully maybe the first break somewhere in there, we'll double-check them, and then I want to get them to Judge Newton's JA before she's supposed to go home for the evening. So when the instructions come up, Mr. Trevina, have some lawyer at your table read them, okay?
Thank you, Judge.
All right, so do you want to rest now and renew your motion, and then when we come back from our comfort break, we can go right into closings? You can say rest, and then we'll do closings? You're not calling anybody else now, are you?
No, Judge.
Okay, good, all right. So you want to rest for the record?
Yes, Your Honor.
Okay.
At this time, the defense rests.
Okay?
Now we renew our motion for judgment of acquittal.
Uh-huh.
We again argue that we believe that the evidence is legally insufficient to sustain the offense of robbery, the underlying charge for the primary offense of felony murder in the first degree. I would reiterate that the state has failed to rebut every reasonable hypothesis of innocence in this case, and that in their failure to accomplish that, there is no other course of action that would be appropriate than the court to enter a judgment of acquittal. The law is very well settled about the requirement before a case can get to the jury that the state excludes any of the defendant's reasonable hypotheses of innocence, I believe of which at least one or more were presented during the course of the trial. We also would argue that the state has failed to establish a prima facie case of the necessary elements. I won't elaborate beyond that. I will preserve the record as to that issue on sufficiency of evidence. I would also preserve the record, our objection to the refusal to instruct the jury on an independent act. I would raise again the issue of the language of the indictment being problematic in this case. I understand the court's ruling in that matter. At this time, I would also like to preserve the record and let the record reflect that we maintain all our previous objections. I understand the court has ruled on those. Nevertheless, for preservation in the event of an appeal, we want the record clear that we've waived nothing in terms of any prior objections unless it was explicitly indicated at the time.
Thank you very much.
Thank you, Judge.
Who's responding to the JOA motion?
Judge, we would rely on prior argument, and in the light most favorable to the state, there is sufficient evidence to go before the jury.
Okay. And the standard shifts somewhat when we come to this point, but I think there's still more than enough evidence to get this case to the jury. It is clearly a jury question, and we will give them the opportunity to decide, and your motions are denied, and I'll abide by all my prior rulings. Okay. So, Madam Reporter, do you want 10 minutes?
That's it.
Okay. So we have a 10-minute comfort break, which everyone should take. Miss Me, I want you to go in the back for the 10 minutes, okay? Because this is going to be a long period of time. I will take one break certainly, and maybe more because we got to do the instructions, but we'll see. Who's going first?
I am, Your Honor.
All right, very good. Okay.
All rise. Court is in recess for 10 minutes according to the courtroom clock.
I couldn't find my, but you can keep it. Okay. It has to be a felony. It has to be a non-enumerated felony.
So somebody dies, you're going to sale of cocaine. that would be charged, or could be charged with murder.
Right.
Is that up there as a life felony?
No, but 10-20 life loss. So, or the reclassification could actually, because it would be actually a first-degree felony because of the reclassification.
Gotcha. And his points may exceed the statutory maximum.
Right. It's your drug rip gone bad.